Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And welcome to the Jury Thinks What, a trial lawyer podcast by trial lawyers for trial lawyers. And as always, this is Saul Gruber from Gruber Trial Consulting as your host. The purpose of this podcast is to help all lawyers get better at what we do, especially if we're trying cases. The idea is to have many guests on for each session, not necessarily those you know, but those that are in the trenches trying cases, to give us some ideas, some help, and some assistance on doing things in litigation to make sure we maximize our clients' recovery. Again, I'm Saul Gruber from Gruber Trial Consulting, your host. If you are not a subscriber to this podcast, please subscribe. And you can get this podcast anywhere you get your podcasts, whether it be Apple, Spotify. We are on the Lawyer Minds ecosystem. And I also ask that you take a look at Gruber Trial Consulting's YouTube channels for trial tips and nursing home minutes. And now let's get to the show. Again, this is Saul Gruber from Gruber Trial Consulting back on the Jury Thinks What, a podcast by trial lawyers for trial lawyers. Apparently I can't speak today. And today we've got both Isobel Thomas and Matt Laird. They are partners out of Colorado, along with Jennifer Keel, doing significant medical malpractice cases, nursing home cases all over the country. Isn't that right, guys? You're now doing this stuff all over the country?
We are, Saul. Yeah, thanks for having us. So we do cases all over.
Well, thanks for joining us. And I know Jennifer, your partner that isn't here today, is one of the people that I rely on anytime I have questions about electronic medical records. She knows it all about that.
Jen really does know it all, I'd say, and Matt knows quite a bit about it as well. Luckily, I don't have to learn it because they know it so well.
That's true. So thank you for joining us, Isobel, and Matt. Good to see you.
Good to see you too.
I see you're standing. I see you're standing.
Standing, trying to get a little bit of exercise.
I like that. I'm sitting.
I'm sitting too, Saul.
Yeah,
the other ones are sitting.
That's what we do. So both of you try cases for a living. Is that fair?
Yep. That's absolutely fair.
One of the things we're trying to do is have people on, not people who just write the books and have great ideas about trying cases. I want to have people on the podcast that I know are actually out there picking the juries, and where we can have conversations that really can help lawyers. And then that's kind of the goal of the podcast. So, and I know the two of you can help because you always helped me when I was in practice. So there's no reason why you can't help everybody who's listening. What's it like out in Colorado with this plague that we have now of COVID? Anything getting tried yet?
It's a good question, and I think it's one of these things we're trying to keep up to date on, and it kind of changes daily, right, Matt? I mean, I think there actually have been a few civil cases we've learned about with some good results, not nursing home or med mal. I think they were more PI, right, Matt?
Yeah, they're trying some cases. I think the problem, it's been focused on the criminal cases right now, so there's a big backlog on the PI cases particularly. Everybody has to wear masks. And so I think that's been one of the constant issues that everybody discusses on our listserv, at least, is what type of mask you need to wear and whether or not you can do it effectively and still communicate with the jury or not. So
I'll tell you, one of my clients from our consulting firm just tried a medical malpractice case in Ohio. And we were out there and helping them, and they wore a mask unless they were talking. So when you were questioning a witness or talking to the jury, you didn't have to wear a mask, but the jury wore a mask. And I thought they could connect pretty well just with their eyes and things of that nature. It seemed like there was a good connection. And I had Brendan Lupitin on. I don't know if either of you guys know him.
Big win.
Yeah. And we did a two-part podcast. One drops, I think, today or tomorrow. Although by the time this is seen, it's a month ago. And he's really a smart guy. And I know the three of us, Isabel, Matt, and I have always had conversations about themes and what we really want to do. Well, Brendan's a master at it. And he hit for, I think, 10.8 million in a brain damage med mal case in Pennsylvania. And his position was he could still connect. And they had to wear a mask when they were doing the questioning.
Oh, wow.
And he still felt he could. I mean, I think at the end of the day, we're storytellers. And if we really hone in our craft, we could do it even with a mask.
Right, hopefully. And the other thing is we have friends who were going to go to trial and they settled and they were going to wear those clear masks, which I think are a good idea too, if you can find them.
Amazon has everything, for better or for worse. So I know, because you guys are doing so much medical malpractice cases, I really wanted to talk to you about experts, and most notably the defense experts. What you do with them, what you look for. Matt, when you get a defense expert's name, how does it work in Colorado? Do you have reports?
We do have reports, yeah. So we're, I think what you were going to go for was sort of what do we do? I think that we start hitting everybody up we possibly can and trying to figure out who this person is, whether or not we've got some, we can get some paper on them, or there's some transcripts of some prior depots. But, we just hit out everybody that we know. And the good thing about a lot of the listservs that we're on, these people are actually really responsive. And so it's just all about getting in there, trying to dig up as much information as we possibly can, as early as we can. And the other thing that we find is that oftentimes our experts that we're already communicating with on our side, those people have great ideas about where we can dig up additional stuff.
Interesting. So let's unpack that a little. So I know both of you from AAJ. And I know both of you from the various lists we're all on for medical malpractice and nursing home, but you do a lot of unfortunate birth cases and baby cases. Are there separate listservs for that?
There are, through AAJ. So there's the birth trauma listserv, and then there's a separate medical negligence one. We know you obviously from the nursing home, but I think they have tons of different litigation groups through AAJ, but yeah, we do a lot of birth cases as well. And we've got, but Matt's right. We still hit I'll still put, like, if it's a birth case, I'll still put it on the nursing home saying, guys, it's off topic, but I don't know, maybe Saul, you've got a former partner who knows one of my defense experts, right. And you're going to see it and you're going to send it to your former colleague who's going to help us out, or vice versa. So we hit all the listservs. Now,
I know from experience, Isabel is very big with keeping books on experts. Yeah. She always, anything you guys get, I always feel like Isabel's the first person to say, I have a book on that person, I'll get it out to you. Do you find that other lawyers are that helpful to you?
I think they try to be, right, Matt? I think, for the most part, I think, and that's how we know you, because you helped us on something. Right. And that's how we got to be such good friends. We had that drink in Miami a couple of years ago. Yep. So, but I think, yeah, for the most part, and I think what happens is sometimes we're all busy doing our stuff. And that's why we hit all the different lists, because sometimes someone will miss an email. I keep an eye on the email all the time, which probably drives everyone crazy. But yeah, I think people try to help when they can help. But sometimes, that's another reason we do what Matt said is we'll read what is sent to us, and they might say, well, I gave a plaintiff's deposition for, to again use like your former firm or someone's, I gave a plaintiff's deposition for this person in New Jersey, right. And not necessarily on their testimonial history list. And we'll think, oh, well, we got to reach out. Or I think I've done this with you where I've said, Saul, do you know so-and-so? Because I'm trying to get them to return my call. But yeah, I think people try to help. And I think, and we've certainly gotten books on people, which is great. And they kind of all go into our database.
Absolutely. All right. So you reach out to the listservs and you try to get whatever information on that expert, no matter who the expert is, or you may have your own book on them already, I guess.
Right. Right. But we still supplement the book because,
okay, good.
Even if it's, and we talked kind of before we started, sometimes we see these frequent flyers and we may have a book from 3 years ago or 4 years ago. And then I'll just or Matt or I or Jennifer will put the feelers out and say, send us everything else. And we kind of cull through it because you can find some real gems in there.
Absolutely. I think the best thing about getting some of those documents is if it's not OCR, you OCR everything. And then you could just do a search of words or because sometimes I get those books and there's, 10,000 pages.
Mm-hmm.
I don't read 10,000 pages ever of anything. I don't know about you guys.
Sadly, we do. I mean, I will look at these depositions, and sometimes, for example, we had a defendant who was his own expert in a case we tried last year, and he does a ton of IME stuff, not on med-mal, but around, he's kind of a very well-known defense expert around town. And it was interesting. In one of the, I think, implied allegations in our case is that he took our guy to surgery, for the financial benefit, and that our guy really didn't need this surgery. And it was something we didn't flesh out as well as we would have wanted to because of pretrial limitations and things. But a colleague of ours sent us, they were like auto accidents. This was a spine surgery case. The injuries were completely different, but he had been ordered by a judge north of Denver in the middle of trial to produce all of his income from expert work. And he was really pissed about it. And it came out, again, it's not a case that I would think, oh, this has relevance to our spine surgery case. He's basically saying, oh, whoever this was in the auto accident was not as injured as they're saying they are, and I've done the IME, et cetera. But he had testified in court in front of the judge that he was making, it was something like $492,000 a year from testifying alone. And then he made this point about saying, well, that's really not all my income. He was trying to say, I'm not a defense whore, but he ended up saying that's only 10 to 15% of my overall income. So of course, the reason that was so helpful to us is we were saying, well, so that means he's making $5 million a year operating on people who probably don't need to be operated on. And so, and again, I'm not reading it, and I don't think Matt is either. We're not reading it line by line by line, but flipping through it, and we don't really give it to a paralegal because there's just gems in there that, and again, and that guy, because he testifies all the time, that's exactly what we did, is that we would look through one deposition and they would say, well, I gave these 5 depositions last week, and we had got his testimonial history, and the week that he had injured our client, I think he had given 3 depositions in other matters.
And this is somebody who's the defendant in your case, not just a defense expert.
Right.
So it's even more damning.
Right. And then, not to jump ahead, but they decided, I think not very intelligently, to name him as his own expert. And so we were allowed to depose him a second and a third time, and he was just furious about it. And
do you think they named him as his own expert because he forced them to?
That's a good question. What do you think, Matt?
I'm not sure. I think that his personality, he probably wanted to.
Yeah.
He wanted to be and they oftentimes they do this where they want to double dip. They want to have their paid expert, but they also want to have their they want their defendant to look like an expert, because it kind of may raise the question in a juror's mind, well, why is the defendant, is he not an expert? Is he not qualified to be an expert in his own case? So I think that may have been kind of part of it as well. But it was beautiful because we get all this discovery on him that we would never have gotten but for them naming him as an expert.
I have a question for both of you, because that brings up something that I've always wrestled with, and it's a good practice tip. If you have a med-mal case, I think we're always going to assume that the doctor is going to testify that he did nothing wrong, right? And that he adhered to the standard of care. In order for him to say that, does the defense have to also name him as an expert?
I don't think so. Do you?
I think I would argue if you want them, if you think strategically that you would want them to name him or her as an expert, then I think the answer is yes. Because if they're going to get in there and say, yes, I didn't do anything wrong, well, then how do you know you didn't? You'd have to do the voir dire on that, and I think they'd have to be qualified as an expert to do it. So I think it depends on if you want to make that decision to treat them as an expert and force them to make that decision, or that commitment rather.
I think it depends on what state you're in, but I do think in some states they actually have to name them as an expert, even if they have paid experts, if they're going to offer an opinion.
Yeah.
And I know that in some states we filed motions in limine to bar them from giving any kind of opinion like that because they were never named as an expert.
Well, and it's hard here because the way our rules work is so, you know, we always have this fight during the case management process. Is a lot of our cases will double up on experts, particularly on cases like this one we're talking about, where you've got spine surgeons and general surgeons, because you don't know what's going to happen to your expert 2 years down the road. You know, what if they have a surgical emergency and
Right.
they can't testify at trial? And so we always strategically, even though it's expensive, want to usually double up on our standard of care people. And there's always an objection early on. You know, now I think, and it's funny, the defense lawyers, they object to it, but they also really want to take the depo because it's more billables. And,
Sure.
and again, when there's two experts on any one side, you can go, well, can I make any distinctions, or, you know, are you two contradicting each other? But they always allow the defendant, I mean, my experience here has been to say, oh, I complied with the standard of care, which is kind of the same thing you're saying,
Yeah.
Saul. But, you know, they don't necessarily have to be named as their own expert. And we see it rarely. I mean, this was the first time we'd seen it in a long time. I don't think it was the best idea, quite frankly, because, again, it allowed us additional depositions and to go into a bunch of stuff like income and things like that that we might not have been able to go into otherwise. But we always make the argument, well, listen, you guys basically have two standard of care people anyway, because your defendant is going to get up, named or not named, and say, I did everything right. You
Right.
know, I complied with the standard of care. And then you're going to bring in your hired gun who's going to say, Dr. So-and-so complied and here's why. And, you know, some judges have found for us that, okay, you get two people, but for the most part, it's usually, I mean, I think it's kind of conventional wisdom here, right, Matt? It's kind of like, of course, the defendant's going to defend himself and they're going to get their own person and you guys only get one person.
Yeah, you know, but you know, it's interesting because I do think, you know, it's something that, like in this case, I think going forward, in our last experience, I think that we will sort of do more of a kind of put up or shut up situation, you know, kind of in terms of, if you're going to be your expert, that's fine, but you're going to be treated like an expert, right? We're
That's
gonna
what
go after you.
that's the position
Yeah, we're
I
gonna go
always
after
want.
you.
Right.
Exactly.
That's the
We're gonna
position
go
I've always
after you.
taken. Yeah.
Right, exactly. And I think, you know, it has been sort of conventional to sort of let them say, well, yes, we did everything, or I did everything right and all this stuff, but not to really necessarily treat them and, you know, go after them as if they were an expert, but just sort of, okay, you know, you're the defendant, whatever. And we're really going to get after your expert. So I think it's a good point and a good distinction. And I think one that you could probably use strategically. You know, if you want to force them to do that, then I think that makes a lot of sense.
And again, I think some states make them name them if they're going to have that opinion and others don't. But I want to get back to what Matt was saying. So you go out on the listservs, I think it was Matt, and you get everything you can find on that particular expert. What's the next thing you do with that defense expert in your litigation, Isobel?
So I think we do what Matt talked about, but what we also do is, you know, depending on who these people are. I mean, we do what Matt said, which is also we talk to our own experts, because particularly sometimes in these smaller specialties, they may know the person or may know the institution they were at and have some intel. So we put our feelers out everywhere. But the other thing that we do a lot of times is, you know, we have a lot of public entity hospitals in Colorado. And you know, we've done this when we've had them as defendants, but what we also do, we have an Open Records Act here. And I think you guys have that Sunshine Record Act or something in Florida.
Yeah, we do.
And Matt and I had a stroke case. I mean, that's a good one because of Florida, 4 years ago that we tried. And they hired two doctors from Mayo Jacksonville or University of Florida Jacksonville. I just remember I went to Jacksonville and had to take these two depots and, you know, back to back on the same day. But, you know, someone on the list had helped us out and said, oh, we've got this Sunshine Act. And so Sunshine Act, open records, whatever, but we do open records requests to the actual institution. So for example, on that case, it was a failure to diagnose stroke case actually at a rehab center. And so we had a neurologist and a neuroradiologist, and so we wanted their stroke policies and we were able to get those. So again, we try any creative way we can to get information. And even I think when we do an SDT on, you know, a depot notice, no one ever shows up with any documents or they move to quash it. And I don't, and we've had this where, locally as well, we've had experts who have come out of, good hospitals that are governmental immunity hospitals, and they've come in sometimes and said something completely opposite to what their own policies say. And, so we try that as well. And you have to have someone where you can get publicly available documents. That obviously doesn't happen with every expert.
And not only that, I bet you can probably reach out on the listserv to people who are in that area who may have sued that hospital.
Right.
Yes,
right.
That's what we did in a case where it was a Philadelphia expert in a pressure ulcer case.
Right.
And he was a family practice, but a really great witness. And he testified that he's not convinced that turning and repositioning a minimum of every 2 hours really is the standard of care. And I already had that hospital's policy that said they have to do it a minimum of every 2 hours. And I showed it to him. I said, you're here, right? You're telling us that you're not sure that's really the standard of care, but we can agree that in the hospital you practice in, the policy is a mandatory turning every 2 hours. He said, yes. So, my thought was, as my cousin Vinny would say, that's all I got for that point. Right. But it's really, a lot of people don't do that, and it's really devastating.
Yeah, no, it is. And I think, and you're absolutely right, because if you can get, and let's face it, I mean, a lot of these people, and we do it too, we hire people who have these beautiful CVs with 100-page CVs, which are good and bad, because we're like, what's hiding in that CV that could potentially hurt? But I agree. And I think if you can get those policies, particularly if it's a public institution, or like you said, reach out to your colleagues, whoever might have them. I mean, we're finding a lot of times, and it's for this reason alone, the defense lawyers are trying to get everyone to enter into these protective orders in individual cases. So then you could call us and I could say, Saul, I've got a policy that's right on point, but I can't share it with you because it's under a protective order. But yeah, no, I think we do things like that, open records. I think what we also do, and I think this is something that people forget about, and it's basic. I hate to say I'm not a tween, but it's like YouTube. I mean, a lot of these people have, stuff on YouTube that it doesn't pop up when you Google search someone. I mean, you specifically have to get on YouTube and, put in, Dr. Saul Gruber and see what comes up. And I mean, we found some really good stuff on YouTube. I mean, actually the hired defense witness for that same spine surgeon we were talking about, I mean, he was pretty well qualified, but he was all over YouTube.
Right.
I mean,
that's interesting.
Yeah, all over. And I mean, and I think it's interesting, or I think it's a good point, that you may not necessarily use everything that you find, but it's information that you can get. And I also like to see someone like that, like this particular neurosurgeon who's from New Jersey. And we've never seen him before. We haven't seen him since, but I can get a sense before I depose him. And obviously it's going to be different, but I can see someone talking like we're talking, so it's not going in completely cold. And what I like to do is, I mean, I'm not going to jump ahead to the deposition, but I love to basically say to these guys as soon as I get in there, I've seen you on YouTube. Or can we rely on what you've said under oath before as truthful? And I've read lots of your depositions. I like to just get it out there and go, here it is, because I think people freak out about that, going, what have you read about me? What have you seen about me?
Yeah. I mean, we've had certain people where we've brought a ton of transcripts to either trial or a deposition and have asked that question, not necessarily impeaching them, but say, look, I've read all of this. Mm-hmm. I don't want to have to ask you all these questions. I can rely on this as accurate. And you were telling the truth, right? Right. So that, and what are they going to say? No.
Right.
I mean, I guess they really should say, well, unless you're taking it out of context, all the opinions I gave were about those cases. And then you duel with them a little, but yeah, I agree. And I think I always like to, when I took a deposition of anybody, I always like to, unless it was an aide or someone that I had to really reach out to, I always like to dominate, like almost to say, all right, here's what I know. Here's what I know about you. Now let's start. Right. And see how that goes.
No, and I agree with you. And I think I love to say something, well, you testified in the Smith case and da-da-da-da-da-da. And, just to throw out a couple of those nuggets, I've done my homework. So my eyes on you, and, Matt and Jen, I think, do the same, which is, just so you know, we've done our homework.
All right. So Matt, I'm going to go to you. I'm going to go to the big question that I'm waiting to ask. So you get the name, you get the transcripts, you also get a report, at least in Colorado, correct?
We do.
Now, there are also states you don't get a report that you've tried cases in.
Right.
Yeah.
Where you get in and you just hope for the best. Let's not talk about those states yet. But now you've got that. You go through your discovery. Are you going to take the defense expert's deposition?
It just depends. I mean, it's funny because, we have this discussion all the time, and we're always thinking about, does it make sense or does it not make sense? What I will say is that I think every time we have ended up taking a deposition at trial, we've been happy we had that deposition, right? So, because there's just always, something always comes up during the deposition. It may be a nothing burger during the deposition, but all of a sudden at trial, something pops out of this guy or gal's, out of what they're saying, and all of a sudden you're like, well, that's not exactly what you said at your deposition. Then we get to go back and we get to open up the trial or the deposition transcript and impeach them. And so, we've never regretted having that. There is something fun, and I think there's something interesting about ambushing an expert at trial as well. We in our most recent trial, we did both. So there was a guy an expert that I did at trial, and we never had done the deposition. And I think there were some things that I really liked about ambushing him at trial with, but there's a couple things that I kind of wish I had him committed to prior to his prior to trial, because I think I could have gotten him on a couple of things a little bit better that I ended up doing. So I think it totally depends.
I
will say I do think one of the big factors I think that is how much does this person do this expert work, right? If you have 50 deposition transcripts, and this is exactly what this expert does every single time in every single case, I don't know that it makes a lot of sense to do a deposition. If this is a frequent flyer, jump on them at trial, but it may just be sort of a waste of your client's money and your time to go out and do the deposition. So I think it really depends.
So, because normally, if I'm not mistaken, you're paying for that expert's time when you depose them.
Right, absolutely.
And they always give you the 4-hour minimum or something silly.
Yeah, exactly. And, we are firm believers, and you've got to videotape all depositions, because it's just, you lose everything in just reading a transcript, right? So,
given it's 2020, aren't we all that way now? I understand you guys have been doing it because I know where you both come from as well. Law firm before you started your own firm, they always did it there, as I recall. But I always deposed. I always videotaped it. Now I think everybody is, right? Yeah. It's almost it's almost malpractice not to, but it's almost not quite.
Right. The defense, it's still around here though. Defense oftentimes won't do it, which I think is huge for us. I think it's great.
Well, it's really huge for us because there's a lot of times I think if they videotape the plaintiff's deposition, the case may not be going to trial.
Yeah, exactly.
But interesting. So if I get what you're saying, Matt, it's really depends on the case and it depends on the issue. And if you were able to do all the things you want to do before that and obtained a lot of information on that expert, you can forego the deposition.
I think that's true. And I think that probably ties into, I think both Isobel and I are a little bit type A, and we both want control over the whole situation. So, I think we're better at sort of, we want to know exactly what this person is saying. And there are other people who, handle it much better when they're just sort of free flowing and they're just, whatever. That's not really the way that we I think we practice. But I think, it's just, we have never regretted doing a deposition of an expert, because we know exactly what's going to happen at trial, and we know what they're, we don't know exactly what's going to happen at trial, but we at least know what the parameters of their opinions are going to be.
So Isobel, let me jump to you and give you the other side of that argument. And again, I don't think there's a right or wrong. I think it's just whatever you're comfortable with is what it comes down. But that's all of trial law, isn't it? I'm not going to ask a question like Keith Mitnick, because I just don't have a Southern drawl. I'm going to ask it like me and be happy with it. Right. But I know when I practiced, I did not like to take a lot of experts' deps. Now, granted, I practice in a state that had reports, and given that most of my trials were limited to nursing home, I kind of knew what all the defenses could be anyway. But I thought that I was giving the expert, and just as important, the defense attorney, a chance to understand the case, prep for the case, so that they'd be much more ready at trial. What do you say to something like that?
You know, I see that side of it, but I have to agree with Matt that we've never regretted it. I mean, for the most part, people know what their issues are, but also, like Matt said, I mean, and we all know doing trial, things can change midstream. I mean, something that I think, to use his term, that you thought was a nothing burger turns into a huge burger at trial that you thought was no big deal. And it turns out you think, God, thank God we took that depo. And I think for the most part, I mean, we're dealing with, you know, a very high level of defense lawyer with a lot of insurance dollars behind them. And so I don't think they know, the people we deal with routinely, whether it's in Colorado or outside of Colorado. I mean, it really is a national practice. I mean, there's a big defense firm here that we see on our out-of-state cases, and everyone kind of goes, well, how are two Denver firms on this case in Illinois? And that's just how it is these days.
Yeah,
but
that's happened to me. Kind of funny.
Yeah, but I really think, I mean, people know what those issues are. And I also think, to me, if I had to balance it out, I'd still rather have someone committed to their testimony. You know, we had a guy in this last trial who was not an expert, but he was a very key treater. And it was kind of a boring deposition. I remember Jennifer and I took it, and it was a very technical deposition. It was an interventional radiologist, and we had to go through all these slides, but he was a key witness, and he was kind of equivocal. I mean, he was kind of like, here's what I saw, here's what happened. He was nobody's witness, but he was one of those witnesses that, you know, I just was always worried about. And he showed up at trial, and I thought, okay, well, I've got his deposition. He's basically said what he has said. And he had a note in his record that was a really important note. And he came in and said, well, no, my record's wrong. And we all sat there and went, what? And so I went through the whole thing. Like, I took your deposition for 4 hours. You had an errata sheet. You had my cell phone. You and I met last week. You know, you never told me any of this. And it was kind of the thing of like, God, I don't know what he's going to say. But I happened to have been very lucky because I was meeting him to prepare for trial, and one of the defense lawyers called him when we were sitting there. And I said, oh, that's the defense lawyer, right? And I remember saying, well, doctor, so you're changing your testimony under oath, and you're changing your record, and you never went back and changed your record in the actual record. But I said, you met with the defense lawyers, right? And he said, yeah. And I said, well, who did you meet with? Oh, I'm really not good with names. I said, well, great. They're all sitting right here. So we pointed them all out. And we had 6 defense lawyers. He had met with 5 of them. And he basically said, I couldn't believe it. He said, I go, well, where did you first learn that, you know, how did you come to believe that your record as someone who was in this OR was wrong? Well, the defense lawyers told me that my recollection and record wasn't really in line with what they say happened, or something like that.
Oh,
right, Matt? Oh, yeah. I mean, it was like a gift.
Wow.
And it didn't matter what he said after. We used a closing slide in close, which was his picture with 5 defense lawyers around his head. And it didn't matter what he said. I mean, he lost all credibility. And so even though, and they were trying to flip him almost to an expert mid-trial, and also to really say this didn't really happen. And so I'm so glad we took that deposition. And you know, and he's someone who was not an expert. I mean, you would think would be committed to the record that he dictated, wrote, and signed, and never changed.
I mean, you would also think that's something that may follow him the rest of his career. If he ever, I mean, God forbid he ever gets sued. Yeah. You know, that's going to be something that's there. But I think you both said it best. You said you've never regretted taking a deposition, which I think is kind of the key, right? I mean, there's 2 sides of that coin. I know on my side, there have been times I have regretted not taking the dep. Mm-hmm. And on your side, you've never regretted. So I think that gives a lot of information to those who are jumping into med mal cases, perhaps that haven't been in there before and want to try to save money and not take the deps.
Well, and when we do regret it, it's usually temporary when you're writing that damn check. I mean, that check is painful. I mean, on this particular case, that neurosurgeon who was a retained expert, he was $1,800 an hour, but they had a general surgeon who was $2,375 an hour, and we asked the court to reduce it. And they said, oh no, we wouldn't. Luckily, we've been awarded those costs because we won the trial.
Right.
But I mean, think about that, basically $2,400 an hour to take a deposition. And I mean, you do sit there and go, and I mean, when someone's that expensive, I think we sit down and go, is it really worth it to take this deposition? Because you're basically talking about $10,000 out of our pocket and our client's pocket ultimately. But, you know, that deposition, that guy who Matt and I were at that deposition, and that guy, you know, he never showed up at trial. And I think it's because the deposition went well, and he could have been difficult for us at trial, and they kept kind of threatening they were going to bring him to trial, but they didn't. But I mean, that was money well spent. But exactly, it is, you know, I see it both ways, but for the most part, we generally, unless it's someone we see all the time, like you're talking about with nursing home cases, especially if it's someone we've never seen, I think get in there, take the deposition, you know, even if it's for an hour or two, get a sense of them. But, you know, the other thing is, I mean, they should be committed to their reports. But again, we've had it where people say, oh no, this is a reasonable extrapolation from the report, you know, and then we've also had it against us where people say, no, if it's not in those four corners, nothing else is coming in.
Well, one thing I'm pretty sure the defense always takes our experts' depositions.
Yeah.
Right? That's not even an issue for them.
Mm-hmm.
That's, you know, as soon as you're getting close to discovery being over, they want the deposition. I mean, normally we're arguing whether they get the deposition before I get their report, right? That's the normal argument. So let me ask you this question, because okay, Matt, you were going to say something.
Yeah, sorry. You know, one thing I was going to say, just sort of thinking about this, and that is that I think one of the other arguments to do it is, you know, think about the impact of being able to say, well, isn't it true, under oath, you said this, versus where in your report is this opinion?
Right.
You know, what's the impact on a jury? I think a jury is going to be a lot more, you know, kind of impacted by the fact that this person lied or said something contradictory, as opposed to, you know, they didn't explain it thoroughly in their report. And you also, I mean, when you're doing it, when you're relying on the report and they're saying something that's outside of the report, you keep having to get up and go in front of the judge and say, Judge, you know, and it just looks like you're whining about something that the jury doesn't care. Like, oh, you wrote something that's outside of a report. Who cares? What is that? What impact is it? Whereas
that's a great point.
They say, right, you know, if they say, you know, my opinion today is this, and you get to say, well, that's not what it was, you know, when we did your deposition, I think a jury is going to be a lot more impacted by that than they are by the technical argument. And what are you going to get? You're going to get a jury instruction from the judge if they testify outside of their opinion. Really, so the judge now has highlighted it for the jury again, and so it's just like, I just think that maybe even more of an argument for doing it. Because
how do you guys deal with this? Because this used to always infuriate me, where I would then ask the question, I just want to make sure, have you now given us all of your opinions that you intend to testify at trial? And the answer is, after an objection, well, it depends on what comes up at trial. I may have other opinions depending on what comes out.
Yeah. I mean, I think that's one that it's a really, you know, snaky.
I mean, you really want to go and smack the expert.
Oh, it's super pimpy. I mean, it's super pimpy. And I think, you know, and maybe Matt has better ideas than me. I kind of just do the same thing. I do kind of the laundry list, like you started, but doctor, you've done this. And that's where if someone really is like a frequent testifier, that it kind of helps be like, doctor, come on, you've given 300 depositions as a defense expert. You know how this works. And what I always say, it's almost like what happened with that treater, which just, we were, you know, lucked out on it. But, you know, I go through the same laundry list, which is, you know, this is my only opportunity. You know, you wrote this report, you put everything into it, you had everything you needed. There's nothing that you felt you needed that you didn't have. You understand that I don't want to be surprised. I'm relying on you. And I kind of try and put it back on them. We're relying on you to tell us everything. And I think it's one of those things you have to kind of say, yes, it depends what came up. Well, no, but doctor, you know, you haven't asked for anything else. You've talked to Mr. Defense Attorney 20 times by your bill. nothing has come up, and can we have the agreement that if for some reason you do review additional materials, you will let Mr. So-and-so know so I can come back and redepose you. And I think, that's the best I can do. I'd love it if someone had better ideas, but, at least then if they show up and then you can say, well, we had the agreement, doctor, right? We have the agreement that you were going to let us know. And now you're telling this jury that you got these documents 2 months ago and you've changed your opinion or you've added to your opinion, but you never let me know like we had agreed upon.
Okay, so Isobel, for everybody who's listening, just gave you the script for what you have to say when they say that, and they will. And that's funny because I like yours better with the agreement, but mine was the same thing. That you knew when you wrote your report, everybody would be relying on what you found. You knew you'd be testifying, but I love the agreement. That's wonderful.
Oh, thanks. Yeah. Yeah. But I do think, and the other thing is there's a colleague of ours in town here, and I think this is also a good idea. And I don't think I've ever done this, but they're supposed to show up, or we're supposed to produce expert files, right? 7 or 10 days before the deposition. And you don't reproduce all the medical records. And again, invariably there's stuff missing when we get these files. But a friend of ours says at the deposition, I think it's a great idea, and I keep meaning to incorporate it, where he'll say, well, doctor, if you create any more notes, any more invoices, and he'll hand them a manila envelope or folder and say, I'm going to ask you to put anything that you do from this point until trial in 6 months into this folder, and you'll bring this folder to trial. And I think that's brilliant. I've not done it. And so again, they either have to show up with the folder, or, well, we had the agreement, but I didn't show up with the folder, and then I'm just trying to sandbag you. I think it's a really good idea, and it's not mine.
I think it's brilliant. Well, most of our great ideas, I mean, let's face it, we steal or we borrow or we heard from somebody else. It's just the nature of the beast. But those two answers, and the one that Matt's about to give on my next question, are the reason we have this podcast. That lawyers can go listen to this, and that will prepare them where they would be sweating if they've never tried a med mal case before going into it. So that's phenomenal.
Good.
So Matt, I'm coming back to you. You're on the bottom of my list here as it looks on my computer screen. One thing that I've always been not impressed with are the financials of experts, because I tend to think, based on my own trials and a lot of the focus groups we've been doing, is jurors know that experts are paid. They expect them to be paid, and they're not really that upset that they are being paid. And I know you earlier talked about the financials. How do you deal with that? In discovery, do you go after the financials of the experts?
So I think like you said, so we've had the exact same experience. I mean, every juror that we've ever polled at the end of a trial says, you guys made a big deal, or they made a big deal about how much was being paid. We don't care. We really don't care. There have been a few exceptions, but for most of it is that, we don't care. But I think the experts care, right? So I think we go after their financials like this is going to be a big deal, because we want them to be a little afraid of the fact that they're charging so freaking much for their opinion. And this is such a big deal this is a big thing in terms of how they make their money. And I think that may be the bigger point, the latter, is that the percentage or the time that they spend doing this kind of work is probably more important than the amount of money that they make. Because when somebody, rather than spending time in the clinic helping people doing what they're supposed to be doing, these people come in and they spend all this time doing all this expert work. And, kind of the corollary to that is, do you do it for the plaintiff, or do you do it for the defendant, or you do both? Most people, most defense experts don't do it for both. They do it for the defense. They're frequent flyers. So where's that money coming from? So I don't know that it's the amount of money that is really that important, but it is how much are you doing it? Where is it coming from? And who are you always testifying on behalf of? I mean, obviously, when you get to trial, you throw it around maybe a little bit, but unless there's something unusual about what is being charged, juries don't really care. But I really do like kind of scaring the expert about how much they're charging, because I think it really screws with them a little bit.
So if I get what you're saying is you're always going to do it in discovery, whether you use it at trial is another story.
Exactly. because you never know. I mean, sometimes you might find something out like we did with the defendant, you know, that he was making $5 million a year just because we were going about his, you know, his financial information, and we figured that out. So yeah, but it's fun. It's interesting. I mean, it's always fun to delve into it, and they get a little nervous because I think they don't want anybody to know how much they're making off this stuff.
Well, when I stopped practicing, I guess about 3 years ago now, can't believe it's been that long. You know, what I saw is experts, once you filed your, you know, once they objected to turning over their 1099s, W-2s, whatever it is, we would then get a letter from their personal lawyer saying, look, you know, we're representing them, because nobody really is, for this, and you're not entitled to it. And then we would get into this large fight that really didn't have too much to do with the case.
Right. But
I guess that's good and bad.
It is, but I mean, I think it's interesting because we can't really typically get 1099s here. But there are some well-traveled defense experts, you know, who, if you can get their 1099s, you know, get a judicial order, will just drop out of the case. But, you know, at my prior firm, and again, this was not my idea, it was a good friend of ours, but it was brilliant. And you know, there's a group, and a lot of your listeners probably know it. I won't identify them, but it's a group of statisticians, however you say it, out of California, who comment specifically on life expectancy, generally on brain damaged children. And, you know, they are of that group that if you can get their 1099s, because they're professional testifiers, they'll drop out. But they also have this underlying data that they got from work with the state of California. And so my colleague, you know, my good friend Lorraine Parker, I'll give her the shout out. She's brilliant. She opened up they were named in a CP case we were doing. She opened up an action in California to personally serve the doctor for the data. It wasn't even the 1099s. I think it was the 1099s and the data, but the data was what was really important, because you can't really cross without the data. I mean, it's because you're trying to say, listen, you're basing your opinions here on data. How do I know if that data matches this kid we're talking about? And anyway, so I took the deposition. I remember I showed up, and it's a one-up from what you said, Saul. This guy shows up with his personal lawyer. He's a retained expert, shows up with his own personal lawyer to the deposition where he's an expert, and he's basically instructing this guy not to answer certain questions. I'm like, how is this ever going to happen? I mean, we ended up settling the case, but I'm like, what? Can you imagine what fun that would be, a trial? Oh, well, doctor, you were a retained expert, but you showed up, you hired your own lawyer to stop me from getting the answers on behalf of
It's a mess. But that goes back to what Matt said. That's why you're doing it sometimes. Not only it's good for the case, but it also creates that extra issue that maybe it gives you the leverage up. Because we know the defense attorneys, especially in medical malpractice and nursing home, will do that to your people in a heartbeat. They have no conscience. And they're all really smart.
Right.
So, so you've taken the debt, you've got the financials if you're going to use them, and the data, Isabel, if you're going to use them. Now you're getting ready to cross-examine the expert. How do you determine what you actually want to cross them on at trial? Because you have all this knowledge and all this information. A lot of it doesn't fit your theme in any way, shape, or form.
Right.
How do you do that?
Well, I think, you know, if we use this last trial we did, I mean, which was, we had 3 separate med mal defendants, 3 kind of separate and distinct sets of allegations with some overlap against everyone. I mean, I think by the time we get to trial, we've already trimmed everything down, right, Matt? And so, I mean, how I do it, and everyone does it differently, but what I do is, this is where I will use a paralegal. I have them go through these depositions in preparation. I mean, ideally we're doing them throughout the case, but let's face it, we're all super busy, you know, we're all procrastinators. So it would be great if, you know, back in the early days, I might have had time to do this, but now
funny.
In preparation for trial. But what I do is I have them break down each topic with the excerpts, not a depo summary, not on page so-and-so he said this, but the actual testimony, like, you know, elective surgery or something like that. And then what each expert said. So I have each topic broken down. And then when I'm going through for my prep, I can kind of go, I don't care about this. Like Matt's talking about income. Sure, we hit income in the depo. I don't care about income, or I'm going to put my income pile over here, because the income pile is actually good if someone comes in and says something, you know, really pimpy, like, oh, well, I didn't see that in the records, or, you know, and you can say, well, doctor, you charged $40,000 and you didn't review the op report that was key. I mean, wouldn't that be important? I mean, that's when I think the money comes into play. But I think, you know, that's how I at least try to trim it down.
I like
and that kind of goes back to what you said and what we've talked with you about themes. Like, what are the themes of our case, or what are the big points I'm going to hit? And I think that's how I at least try to do it in preparation for trial. It doesn't always work that way.
Well, that's interesting though. So you limit it by themes, and then pick your best points on those themes. What about you, Matt? How do you do it?
Pretty much the same thing. You know, I mean, one of the things that I do too, and I think I know Isabel does this as well, and that is, you know, we're talking to our experts as well, right? So we're talking to our people saying, so, you know, we've got our themes, we've got our trial consultants, we've done our jury, you know, the focus groups, and we're in communication with our experts. So what we're trying to do is figure out, you know, amongst all of these different sources of information, what really matters and what's important. And so then that's how we kind of break it down into topics or themes, whatever you want to call it. But you know, relying on all of those people, and then obviously our own instincts as to what's important, and you know, our own proof charts and all that stuff. But yeah, so you break it down. But you know, you got to read it. I think that's the first thing that you got to do, and you got to go through it, and then you get a sense again. You know, I mean, part of trial is relearning the case, because you know, unfortunately, as Isabel said, and I think we all know, we all have a bunch of other things that's going on between the time we took that expert deposition and trial. So you got to reread it, and then you get in touch with all your other people who are helping you kind of put it together and distill it into something small. And you know, that's also kind of goes into the whole idea that, you know, you don't beat them up on every single point. You beat them up on the top 3 to 5 points that you have. You know, that was
really going to be my next question to you. That was absolutely going to be my next question to you. We just tried a case with one of our clients, lawyers, and they had all this list of all these things that clearly were inconsistencies, but no one would care about.
Right.
And I said, just knock them all out, because it's not going to help us at all at trial.
Well, and that's, you know, I mean, it's one of the things that I think all of us lawyers fall into the issue of trying to, you know, we want to prove our point to the extreme, and we want to prove every single thing. We want to show that this person is the liar that we know them to be, but you can't do all of it, and the jury, quite frankly, is going to be pissed if you do it. So, you know, you get in, they're going to lose the big points amongst the little points. So you get in there and you pick those top things, and I think that's really where, you know, talking to your jury consultant, talking to your, you know, listening to the focus group, talking to your expert, those people will help you kind of stop being the lawyer who wants to prove every single thing, and figure out exactly what are those few points that you have got to make with this expert. You know, and then I think you always leave room for the, you know, the extra, whatever it is that the extra expert, you know, that adds in there, and then you have to be ready to jump on whatever that issue is.
And I've told people that if you have nothing at all to cross them on for whatever reason, you could not ask any questions, but I don't have the guts to do that. I don't know if anybody else.
I don't have the guts to do that.
I mean, I have other phrases. I don't have the you know what to do that, but I don't. I would at least take my 5 main points, even if they can't comment on them, and just go over it with them. Especially if it's a nursing home case. Well, when you looked at the chart, you realize they didn't do this, right? It may not matter to their opinion, but I just reprove my case very quickly so that it's an echo of the theme that way.
Well, it is, and if I can pop in, you know, Matt gave me the best idea in the middle of this trial, and it's kind of saying the same thing. It's not so much even with someone where you go, I don't even have anything to ask, but you know, it was one of the defense lawyers, who's probably the best defense lawyer I think we've dealt with, who was of all these 6 defense lawyers on this last case, but he's very good, he's very effective. And he always has this list of, isn't it reasonable questions? And Matt, I remember saying, well, I think you need to flip that on him. And so I started with all the defense experts. I had about 2 pages, and I wouldn't go through 2 pages, but kind of, you know, isn't it reasonable? Like, so we thought our guy had an unnecessary or rushed surgery. So we would say, well, wouldn't it have been reasonable to wait? I mean, you're not talking about standard of care, causation, or damages, but we were saying, you know, he may have needed the surgery eventually, but we should wait until he can get his weight and blood sugar under control. It's elective, do it under controlled circumstances where it's not dangerous. It wasn't urgent. And so I was like, that's the most brilliant thing I've ever heard of, Matt. And I kept repeating it with all these people, and it made them crazy because I just say, what are they going to say? It's not reasonable to wait because they were trying, no, wouldn't it have been reasonable to do it this way? Yeah, that would have been reasonable. And so we're getting all these agreements, and they're going to look like complete jerks if they go, no, it wouldn't have been
What do you think happens? Have you done that at trial?
Yeah, this was a trial.
And has the judge let you ask that?
Yep.
I'm assuming there's going to be an objection that's not the standard of care. It's not the level of proof, anything?
Yeah, I mean, I think we got those objections, but he let it in, and and it was just kind of like, wouldn't it? It's the same questions they ask our guys. We just kind of flipped it on them.
I like that idea.
And it was just a whole list and super basic stuff. Not like, wouldn't it have been reasonable, but it was like, we also had a complaint about the particular device that was used in this back surgery. Wouldn't it have been reasonable to use a different device? Yes. I mean, like, it was Matt's idea, and I thought it was really effective.
So Matt, if you're doing that, will you do that at the deposition as well, or do you save that for trial?
I would save it for trial. And the reason I would save it for trial is because, that may be one where you can kind of tip your hand a little bit too much. And, it sort of goes back to that whole idea that, what you want to be doing for the jury is really narrowing whatever the issue is, what is the actual issue, right? So what are the things we can all agree on? What are the things we can't agree on? And what is that issue? And so if you use those reasonable things, then your expert looks like he's got a reasonable or she's got a reasonable position. And then once you get that, then you drill down as to what is the unreasonable side of this. So I think, we were talking about sort of how we put together our topics and all that stuff, and how you go from the deposition to trial. One of the critical things is figuring out the order of your topics, right? You don't want it, it's got to be some sort of logical flow. And so I think, sort of what we did and what Isobel did really well in our trial was to kind of identify what were those reasonable things, and then dive into the unreasonable opinions that their experts had.
Wow, that's great stuff. Thank you, Matt. Thank you, Isobel. This is great stuff. I really enjoyed this. Thanks so much. Now, Isobel Thomas, Matt Laird, I know your main office is in Colorado, but you're everywhere, right? You've tried a case down here. You're trying cases everywhere.
We are.
If someone wanted to get a hold of you, can they do that just at your office?
Oh, yeah. Yep. So we're kind of in this crazy time. Matt and I are both, if anyone's on YouTube, we're both physically in our own offices within our office suite. But the office, even when we were fully remote, we're on phone forwarding like everyone else is. But yeah, you can call us. It's what's our website, Matt?
I'm gonna put all your contact in the notes. So whether they're listening or watching, they'll have it. I want to thank you both again. Phenomenal information. And I really appreciate it. Again, this is Saul Gruber from Gruber Trial Consulting on The Jury Thinks What on Defense Experts with Matt Laird and Isobel Thomas. Thank you, guys. I really appreciate it.
Thank you, Saul, for having us. Stay safe. It's so good to see you.
Thanks. And again, this is Saul Gruber from Gruber Trial Consulting on The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. I want to thank both Matt Laird and Isobel Thomas for just a fascinating interview where they gave incredible tips on dealing with defense experts, especially in a professional malpractice case, from what to do when you first get their names to whether to depose them or not, and incredible tips when cross-examining them. In fact, if you're handling these cases, you can use what Isobel and Matt said virtually verbatim in your next trial. And if this is something that's new to you, they've given you phenomenal tips that it would normally take years to know from trying cases. I want to thank again Isobel and Matt. They are incredible. Now we'd like to shift a little into our nursing home minute. As all of you know, if you listen, each podcast, we give a nursing home minute with a tip about nursing home cases that Gruber Trial Consulting gives all of our clients. The tip today is when you're trying the case, prepare a trial brief that will knock the socks off the judge. It will be too long. It will be too comprehensive. and the judge will have no choice but to have it and utilize it throughout the entire trial. We include all of the regulations that we believe have been violated, both state and federal. We include any issues regarding surveys, any issues regarding cost reports, any issues regarding depositions, transcripts we want to utilize, boards, copies of the boards are all in there. A lot of times it's 100 to 125 pages, and it's bait stamped. Everybody gets one. Why? The goal is at trial for the judge to be saying in front of the jury, Mr. Plaintiff, let's go to your trial brief, page 97. Does everybody have it? And the arguments are done from there. It shows the jury that you know what you're talking about. It shows the jury that you are prepared, and it shows the jury that you've taken the time to make things go quicker, meaning that you are concerned about the jury. So do your trial briefs, make them complete, make them comprehensive, and it will pay off at the time of trial. Again, this is Saul Gruber from Gruber Trial Consulting, and you're listening to The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. I ask everybody, if you haven't subscribed, go. You can get your podcast. You can get this podcast anywhere you get podcasts, and also go to our YouTube channel for Gruber Trial Consulting, where you can get your weekly trial tips and weekly nursing home minutes. Again, thanks for listening, and look forward to seeing you next time.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.